Good afternoon. I'm Joey Wender, Executive Director of the SHLB Coalition. It's my pleasure to welcome everyone to today's webinar entitled Defending the USF After SCOTUS. It's been a year since Shelby won a landmark victory in Shelby versus Consumers Research, where the Supreme Court upheld the constitutionality of the Universal Service Fund, which includes both E-rate and the rural health care programs. But ongoing legal threats remain. Consumers Research is back at the Fifth Circuit, and they're challenging specific parts of the USF that were not technically decided in the Supreme Court case, which again includes threats to E-rate and rural health care. Shelby's fighting back once again by intervening in the case. And now that the briefs have been filed, the question is, what can we expect from the Fifth Circuit? Legal experts, Jason Neal, Shelby's attorney with the HWG law firm, and Andy Schwartzman, senior counsel for several public interest groups that we partner with every day, are joining us here today to break down the current USF challenge and answer your questions about what is at stake. Shelby's also proud to co-host today's webinar with ALA, the American Library Association. ALA has been with us every step of the way in this case, including submitting an amicus brief in this case, which we'll discuss a little later in the webinar. So to bring this discussion to life, our conversation will be led by myself and with Kristen Cora, our terrific policy counsel at Shelby. Now, before we get started, just a couple logistics. One, the webinar is being recorded and will be available on our website afterwards. Audience members are muted, but we encourage you to use the Q&A box, not the chat box, to send us your questions that we should get to towards the end. As always, please follow Shelby at Shelby Coalition on LinkedIn, Facebook, X, and YouTube. Also, we want to thank our corporate sponsors, Ready, Zayo, T-Mobile, Cisco, and Tirana. We would not be able to engage in our work without their financial support. Finally, if you enjoy and value these webinars, please consider becoming a Shelby member if you are not one already. All right, it's time to dig in here. So let's start with Andy. Can you take us back to a grand time, the summer of 2025, when we won an historic case at the Supreme Court? Can you briefly remind us how the Supreme Court came to that conclusion? Andy.
Well, the Universal Service Fund is a innocent victim, I would say, of a conservative a conservative wing of the conservatives, judicial conservatives, who seek to be attacking the administrative state. And one of the targets that they've had for many years was some New Deal era precedents involving what is called the non-delegation doctrine. So they seized upon USF as a way to press that issue and hope that they could get the Supreme Court to overrule those 1935 era Supreme Court decisions and weaken the power of the executive branch and independent agencies to exercise congressional authority, calling in short for much more specific kind of legislative authority for agencies to do things. The result of that is a flat out challenge to both the Universal Service Fund itself, Section 254 of the Communications Act, as adopted in 1996, and a related challenge to the very existence of USAC, the Universal Service Administrative Company, were mounted, for that reason. In that sense, what we wound up with the decision, upholding the Universal Service Fund and USAC, left us exactly where we were before the litigation started. we derive a few benefits from the successful outcome of the case in the Supreme Court, guidance for Congress and clarity as to the authority of the Universal Service Fund. Uh, Now, what's happened after that, which we'll be going into, is a little bit different because having sort of noticed the Universal Service Fund, the current attack is more is has elements of just let's get universal service, I think, as well as this kind of broader uh, 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 administrative state challenge that they brought. Uh, the case was brought in they filed multiple circuits to try to set up a circuit split and try to get something that could get to the Supreme Court. They failed in the Sixth Circuit. They failed in the 11th Circuit. They gave up in the D.C. Circuit, but they got a Fifth Circuit decision. We won in the first round before a three-judge panel. It went to the full Fifth Circuit on bank, as I think people would know. This is the most conservative of the circuits in the country, and that kind of forced a Supreme Court case and went to the Supreme Court. We won a very decisive win in the Supreme Court uh, with a really strong opinion, and so that took us to here. But then there's footnote 9, which we will get into.
All
Joey?
right. Thank you, Andy. Okay, so I'm going to turn it over to Jason. So, Jason, I think a lot of people are wondering, okay, so we won last year, right? So, why are we here now? What is this new case about? So, can you tell us how is this case different from the SCOTUS case? What new issues are involved? What are some of the primary arguments that consumers research is bringing now?
Sure thing, Kristen. And I agree with what Andy said. I think that the way that this litigation first came about was probably very kind of ideologically driven, that there was a theory looking for cases. They wanted to bring this non-delegation doctrine up ultimately to the Supreme Court, and the Universal Service Fund was one case that parties brought to try to do that. So what we ended up with in the previous case is I would just describe as like a full frontal assault on the constitutionality of the Universal Service Fund. The entire fund was at issue. Their arguments were, ultimately about whether the entire statute adequately guided the FCC in its discretion. And then they also had these arguments about USAC that they similarly said kind of taint the entire program. With the victory, again, I would love to stay in the year ago grand time when we first
No,
got Justice Kagan's opinion, because it was such a great opinion, and so pleased to see the
I
victory.
can send you a link.
What we have after the sort of full frontal assault is what's left in the case. So Andy mentioned footnote 9, where Justice Kagan identified some constitutional arguments about particular parts of Section 254 of this statute that were not before the court, because consumers research hadn't focused on those provisions in the case as it was before. They were focused on the entirety of USF. The Supreme Court said the entirety of USF is fine, but there are these couple of provisions that we just are not specifically resolving today because we don't need to, and it hasn't been briefed before us. So it would sort of be inappropriate to rule on those things now, not having had the briefing for it. In his dissent, Justice Gorsuch focused on those parts of USF and the statute that were in that footnote 9 that Andy mentioned, and he sort of invited these parties or others,
I sent you a
hey,
link.
you can go ahead and bring more litigation later to focus on these issues that we haven't decided. So that's the first set of arguments that we have here. It's sort of the cleanup of the constitutional arguments. It's still this non-delegation theory, but it is much more focused on, okay, even if Congress could allow the FCC to do this full program, are there certain parts where it just hasn't adequately guided the FCC? And we will talk about this, but of course our answer is no, there's no new problem here. Just as the entirety of USF passes muster under this constitutional doctrine, these important but smaller parts of the statute also guide the FCC's discretion. So that's number one. Number two is a set of statutory arguments, essentially, again, relying heavily on Justice Gorsuch's dissent. So I'll focus on what the majority said because that's what 6 justices of the Supreme Court signed on to. The majority of the court said, here is how Section 254, this provision of the Communications Act works. We line that up against how the FCC administers the Universal Service Fund, and we give it a thumbs up. The FCC follows the statute, and the statute contains sufficient constraints for the FCC. Justice Gorsuch disagreed with how the majority of the court interpreted the statute, and he said, you're actually reinterpreting the statute. Well, the way that you're interpreting it is so different from how people have actually understood it to work in the past that you're saving it, but only by changing the meaning of the statute. And Consumers Research now says, well, we agree with Justice Gorsuch. That's not a surprise to us on this side of the case. We agree with Justice Gorsuch. The Supreme Court actually didn't endorse the constitutionality of USF. It reinterpreted the statute to be more strict and constraining than what everybody has thought so far. And so, in their view, the FCC needs to go back and reevaluate effectively all of the Universal Service Fund programs, presumably each quarter when it adopts the contribution factor that is actually what gives rise to the case, and see if any way that it interpreted the statute before is inconsistent with what the Supreme Court said in our case from last year. So that's the second argument. And finally, the third argument is again about USAC, and it's a little bit more targeted than their theory last time. Previously, their theory was that the FCC essentially just hands over USF to USAC. And again, especially when it comes to adopting the contribution factor, that USF decides what the needs of universal service are, how much to charge everybody, and then the FCC just rubber stamps it. The Supreme Court agreed with the government and with SHLB and all of the interveners in that case, but that's just not how the system worked. Now they have some additional arguments about USAC. Number one, that the FCC actually didn't have authority to create USAC when it did a couple of decades ago. Number two, that USAC's role is still so important that they're actually considered officers of the United States that have to be appointed in a certain way. And a couple of other, I don't want to say smaller arguments because they're important, but sort of more down in the weeds arguments like that with respect to USAC. It's not primarily about too much authority being handed to USAC, but sort of whether USAC gets to be a part of this process at all. And again, I want to reiterate, for folks who don't follow kind of the procedure of the case, Consumers Research brings these challenges every quarter when the FCC announces what the contribution factor is going to be. And I think we'll talk about it in this webinar, but I think that's really relevant to the scope of the challenges that should be before a court now, because a lot of this is really asking the FCC, every quarter when you do the math, which is ultimately what it is, to figure out what the contribution factor should be.
Right.
You need to go back and kind of reassess all of this. And it's an opportunity for anybody who has any problems with universal service at all to kind of lob their issue in and bring that to court. And we don't think that that's really how, that's not how you run a railroad. We don't think that that's how the judicial process is supposed to work here. So I will stop there.
So, Jason, I think that's a great summary of Consumer Research's position and argument this round in this litigation. Let's talk about our argument. Let's talk about Shelby's argument. Let's talk about the government's brief. Let's also mention that NTCA, one of our industry partners, let's talk about their briefs. And in particular, one of the things that stood out in NTCA briefs is, no matter how much Consumers Research wants to, rely on Justice Gorsuch's dissent, it's the dissent. It's not the law. And so let's talk us through a little bit, Jason, about the arguments we're making, and then we'll go to Andy to discuss as well the American Library Association's amicus and other issues that we're bringing up.
Sure thing, Joey. I will try to be a little bit more concise than I was in the initial summary. The government filed a response brief. They're the main counterparty, the United States and the FCC, separate parties. So they filed one brief. SHLB and Andy's clients filed another intervener's brief. And then, as you mentioned, NTCA filed its own intervener's brief. So we all got a shot at responding to consumers' research here. I would say the briefs were largely very complementary. The government attacks these issues from one perspective, which is, we are the government. We're trying to defend the constitutionality and our compliance with the statute of the actual government program or as the government. So they occupy obviously a really important position here, and it's important to see them defending USF. We as interveners approach the case, ultimately urging the same result, but from the standpoint of stakeholders and beneficiaries and participants in the program who, number one, can speak to the importance of the USF programs out in the real world in a way that the government, we always hope understands, but maybe is a little bit higher level about. So that's one thing that we tried to do in the briefs. And number two is just to provide the perspective of, hey, we're not the government. This isn't our program to defend, but we believe in this program, and we have seen in practice how the FCC administers it, how Congress has amended the statutes over time, how Congress has adopted further statutes that affect USF, and just telling that story from our perspective. So, for each of the three arguments essentially that I laid out that consumers research has raised here, all of us more or less responded to each of those in turn. I would say that a consistent theme across the briefs was consumers research is citing Justice Gorsuch in his dissent quite a bit. I think NTCA said it very well. What really matters here is what the majority said. And what the majority said is this statute is constitutional. The majority did not suggest that there are any constitutional problems with the couple of provisions that we'll talk about E-rate and RHC. It didn't say there's a problem there. It just said we're not addressing those because they're not here in the case. And the reasoning that the Supreme Court used in upholding the delegation to the FCC as a whole also answers any of these arguments about the propriety of the delegation to the FCC on these particular provisions. And then we go into, assessing, doing the statutory interpretation that is sort of the mainstay of these kinds of cases. What are the guardrails that Congress put on the FCC when it comes to E-rate and the rural healthcare program? I will not belabor the statutory text here. I won't read it at everybody, but we have the benefit of the Supreme Court victory, and then we have additional language in these provisions pointed out. With respect to the idea that the Supreme Court reinterpreted the statute and the FCC needs to go look back at that every time, we raised some procedural arguments, and we also raised substantial substantive responses. On the procedural side, it kind of goes back to what I said about, what's the way to run a railroad? Consumers Research files comments in response to the FCC's public notices on the contribution factor every quarter. And every quarter it says, hey, Justice Gorsuch said you're doing this wrong. We think you're doing this wrong. You really ought to change it. They don't say, hey, we've looked at E-rate category 2, and we actually think that in your order in 2007, you misinterpreted the statute. They don't present actual disagreements on how the FCC interprets the statute in the individual programs. And the FCC does a lot of explanation in its orders, some of which we agree with and some of which we don't, about how it understands the statute and how it is complying with the statute. They don't really get into those issues. And so we think that's a real problem for the court here, that they are asking the Fifth Circuit to say, the FCC has been interpreting Section 254 incorrectly in order or after order over the years. But they haven't put any of those orders before the Fifth Circuit. They haven't said what those would be. They haven't said what the actual problem is. And then on the actual merits of that argument, again, we've pointed to how Justice Kagan and 5 other justices of the Supreme Court all agreed in multiple parts of the majority opinion that the FCC has been following what Congress told it to do. And we just think that that's, a pretty plain answer to the statutory issue here. I won't get too far into the USAC arguments because, again, I think a lot of that goes back to how substantial is the role that USAC plays here. I think a lot of that is answered by the Supreme Court's decision from last year. But there are also these sort of tricky down in the weeds issues about the Government Corporation Control Act that are not something that Shelby or Andy got into our brief. But I think NTCA and the government did a very good job handling those in their briefs.
Thank you so much, Jason. Appreciate that. Andy, so Joey alluded to the fact that ALA also submitted an amicus brief. Can you briefly explain what is an amicus and what arguments does ALA primarily make?
Okay, before I do that, having just heard this extremely helpful and lucid explanation from Jason, let me just say that Shelby needs to be very grateful to Jason and his firm. HWG is one of the leading telecom firms in the space, and 4 or so years ago, when they didn't sign on for this, all these cases and going all the way to the Supreme Court and then back down, and they have resources and knowledge and skills. And Jason's partner, who's got a lot of Supreme Court experience, Sean Lev, helped out. Shelby, and they've done the lion's share of the work on the briefs. So Shelby is very, very, very lucky to have this kind of quality representation. So having heard Jason describe the briefs, I wanted to make that point. As far as the ALA is concerned, with some point of pride, having worked at the tech clinic at Georgetown Law School for about 5 years, that clinic filed an amicus brief on behalf of ALA with the Fifth Circuit. And as good amicus briefs do, it fleshes out things that can help inform how a decision is made. Some amicus briefs just kind of repeat what the other briefs say, which is a waste of everybody's time, and judges really don't like that. But what ALA did was say, look, here's some background about how the E-rate program really functions to demonstrate that there are constraints on how the E-rate operates consistent with the requirements of law, how beneficial it is, and ways in which the FCC has designed the E-rate program to fulfill the specific statutory requirements and needs. So it gave a kind of broader background to how this all functions in a way that can inform how a court will approach this decision. So it's a very helpful addition to the case.
Thanks, Andy. And look, we saw it with Justice Kagan as well, and we heard it in the arguments from the bench during oral arguments that there is discussion of what is the real world impact or what are the real world the policy goals of these programs. I thought Justice Kagan put it extremely well during oral arguments and again in the decision last year. So thank you for that, and obviously thank you to ALA. All right, let's turn to both good scenarios and bad scenarios, and then we'll move on to procedure about, what can we expect and timeline moving forward. So we'll go back to Jason. On the positive side, if we win, I think we all know what the outcome is. It's along the lines of what Andy already talked about, which is status quo. We continue along, and these programs continue to exist and do the important work that they're intended to do. I think the question that a lot of people have is, well, what happens if there's a bad outcome, right? What could be the impact? And again, I'll say it before Jason even starts. We don't know what the outcome could be. There are a million different flavors of what the outcome could be. And so we can't say for sure this is not a binary yes or no, but what is at risk here as we move through this litigation?
Well, you took the words right out of my mouth, Joey. But
Sorry.
I think that the decision from the Supreme Court last year is all the proof that you need that this isn't a binary. This was a huge win for us before, but here we now find ourselves again in litigation with some of the issues that weren't addressed in the case before. So the decision tree here, to steal a phrase from somebody else on the call, is big and branching. Bad outcomes could vary, right? Here, consumers research has raised some constitutional arguments that focus on E-rate and the rural healthcare program and parts of those programs. So a bad outcome on the constitutional argument could be the Fifth Circuit saying, we have concerns about the constitutionality of parts of those programs, and maybe the FCC needs to go, take a look at those to figure out which parts are affected. We have this broad theory that the FCC has to go back and look every quarter at what the how all of the USF programs comply with the statute as interpreted by the Supreme Court last year. So you could have a Fifth Circuit decision that said, here's how we understand the Supreme Court to have interpreted Section 254, and we think there are issues. And we think that the FCC needs to go back methodically, somehow to look at every single program and every single order over the years. And I don't know, either report back or issue some orders that then consumers research or others could appeal. We don't know. Again, I think it's one of the challenges of this argument that they're making, that they're kind of saying everything is a problem, but we're not going to tell you what the problem really is. Both of those issues, either the constitutional theory or the statutory interpretation theory, could be disruptive for the FCC's ability to administer USF or to administer E-rate and the rural healthcare. I won't speculate about exactly how that would play out. But if you go back and listen to the way that we talked about this a year or two ago, these are the kinds of things that might be problems that Congress would have to fix if there were to be an adverse outcome here. In contrast to that, I think that the arguments that they make about USAC, if there were a bad outcome there, would tend to be less disruptive for the overall system. USAC is important. USAC plays an important role in helping the FCC determine what the contribution factor is going to be. But we have the Supreme Court decision from last year explaining, the FCC is entitled to rely on their help, but ultimately the FCC is the one that makes the final call here. And so if we were to have an adverse outcome on the USAC issues here, they would just kind of put the pressure on the FCC to do more of that work itself. That is the sort of thing that I think the FCC is well equipped to figure out what it would do. Now, everything I've said so far is kind of the practical, real world outcome here. But as we saw last time, the three judges who decide the case are not always the last stop. In most cases, it is, but this is an important government program. And, on the other side of this case, we have driven opponents who really want to push their arguments. So last time we won pretty handily at the stage where we had three judges from the Fifth Circuit. They then asked the entire Fifth Circuit to rehear the case, and that's where we had the very narrow loss at the Fifth Circuit level. And then we went to the Supreme Court. So all of those things are on the table here, not a guarantee, but a possibility, whether we win or whether we lose. If we win at the panel here, the consumers research could ask the full Fifth Circuit to rehear the case. They don't have to do that. They could go straight to the Supreme Court, or they could just decide they're done for now, or they're going to find other arguments that they want to raise on this program. If we lose here, I would like to think that neither we nor the government would take the loss lightly and just leave it in place. That is a decision that we would have to make if we get to that point, and depending on what the decision is for the Fifth Circuit. So I won't prejudge what SHLB or any of the other parties will want to do. But those are the kinds of decisions that we'll be making.
Yeah, so Jason or Andy, so regardless of whether, and we'll get to the timeline in a few minutes, but regardless of which party wins, whether we win, the government, Shelby and partners, NTCA or Consumers Research wins, is there always an ability to appeal to an en banc hearing, essentially in front of all the justices on the circuit?
Yeah. So I don't want to get overly weedy about this thing, but I think people understand that the Fifth Circuit Court of Appeals is among the more conservative, almost certainly the most conservative of the 11 federal circuits. And it's also one of the largest, not the largest. It's got 17 active judges at the moment. So when a case is heard, it's heard by a panel of 3 judges. And as was the case the first time around, you go before the 3 judges. We drew a pretty good panel against odds the first time. Statistically, we're probably not going to get a very favorable panel. But hopefully they will have been chastened by the Supreme Court and by the kind of more, I'm trying to avoid the word desperate, the graspy way in which they've attempted to try to glean something out of the Justice Gorsuch's dissent and what's left that they hadn't challenged. But the Fifth Circuit is more prone than the other circuits when there is a decision that does not appeal to this kind of broad conservative consensus in that court, to take the cases en banc. En banc is the general pronunciation. It's actually the French en banc, en, new word BANC, and it means all of them. And in that situation, you get a hearing with 17 judges, and they can agree to hear a panel decision if they was convinced that there's reason to think it should be reexamined. That's exactly what happened in our case. And we came pretty close considering the first time, but we lost. And I would expect, if we win, that there would be a petition for rehearing en banc. They have very little to lose in this court by trying. I'm less clear, without knowing what they hold and the circumstances, whether they would get en banc review this time. Plus, the en banc court is busy blowing up other things right now. But that scenario would pertain. Timing becomes interesting there, just if you want to get really deep into the weeds, because we're going here into 2027, and if there's a decision, which end of the year at the earliest, we haven't talked about that, and then there's rehearing, goes into the fall of 27. We're getting pretty close to a different Congress, which may be helpful. And we're getting pretty close to where a different Solicitor General's office might be involved in a Supreme Court decision. I don't want to get too deep into those extreme hypotheticals, but I just point out that since we're sitting on a win, and since the statute remains in effect, we're in no rush to see how this plays out. I'm not looking forward to the en banc review. I'm not saying that's good, but that's what would happen. And then either a panel decision or the en banc decision can be appealed by either side or both sides to the Supreme Court in a petition for certiorari, which is discretionary on the part of the Supreme Court. When the government files a petition for certiorari, it almost always succeeds in getting the Supreme Court to agree to review the case. The percentage of cases brought by other parties to the Supreme Court is much, much lower, and often depends on a split in the circuits, which we had the first time around. So it's very hard to speculate how that part is going to play out. So as we've been alluding to, there's a lot of scenarios here, and we're just going to have to sit back and wait.
Thank you. Thank
Joey,
you.
if I could jump in
Please.
first, two things. Number one, I think I need to thank Andy Schwartzman for his very generous remarks earlier about me and my law firm. He's right that we do have some great resources on these issues, including John Nakahata, who is kind of a library of the 1996 Act and has been a huge resource. So it has been a pleasure to work with Andy throughout this case and with Joey and Kristen and John Windhausen before on behalf of SHLB. So I do want to say thank you for that. Number two, more on point and what people are actually interested in. I think what Andy said about the Fifth Circuit being potentially chastened by the Supreme Court's decision is certainly a possibility. Even if they don't feel chastened, however, the fact of the Supreme Court case before and the fact that we have a decision from the Supreme Court really differentiates this case from the previous one. That's especially true if we end up with the en banc Fifth Circuit. There we had a federal program that only some of the judges really knew much about to begin with, and how the FCC worked and how USAC worked. We also had these arguments about the non-delegation doctrine that some people have been motivated to push the envelope on for decades and decades and decades. Now that's not really the issue in the case anymore. If a judge were particularly interested in the case from that legal perspective, that's not really what this case feels like it's about anymore. The Supreme Court said, we're not changing the non-delegation doctrine right now. We're following the same approach that we have used for years. This statute passes muster. And now if this comes back to a member of the Fifth Circuit, whether it's on the panel or whether it's all of the judges hearing the case at a later stage, they don't need to approach this either from a kind of bare legal lens or from a place of unfamiliarity. They now have a Supreme Court decision they can read that says, here's exactly how we are telling you, lower courts, this statute works and how the constitutional doctrine works. And that is a big shift in how this case proceeds.
And to be clear, that decision was signed by Chief Justice Roberts, Justice Tony Barrett, and Justice Kavanaugh.
Exactly. All of those, all three joined in the decision from Justice Kagan. I think that's very important, Joey.
That's right. Real briefly in the chat, someone asked, and then we'll go to our final question, is there something that Congress could do to reform the USF to structure it in a way to make it harder for entities like Consumers Research to attack it? The answer is yes. I should note that SHLB is engaged in a pretty deep way with a congressional working group that's currently reviewing the Universal Service Fund. We view this as an opportunity to modernize and improve the fund. Right now, what we're discussing here is litigation in which we're simply defending the status quo, but we believe at SHLB that we should be improving the fund. We've also discussed with the working group language they could add to, as you're saying, as the questioner is asking, to essentially shore it up and protect it more from attacks from groups like Consumers Research. All that being said, is we think we're going to win this case. We won the Supreme Court case, and we think that Congress was prescriptive in writing Section 254 of the Telecom Act, which authorizes and put in place the Universal Service Fund, including E-rate and the Rural Healthcare Program. So we're going to go back to Andy and Jason let's ask the final question about timeline, and then we'll give each of them a minute to give their final thought. Jason, what happens next? When do we get, we get oral arguments? When do we get a decision? Are we talking Labor Day, Halloween, Christmas, next year? What are we talking?
We don't know exactly what the timing is going to be, but I can give you a rough estimate from how these cases usually tend to go. So all of the briefs have been filed in this case. If there are any further filings, it's just going to be because some new case was decided and some party in the case wants to let the court know about it. But all the briefs are fully in. Last time there were about 5 months between the filing of all the briefs and the oral argument. So if we use that as sort of measuring stick here, That puts us in about September or October for a possibility for oral argument here. Not a guarantee, but that's a
Yep.
pretty good rough estimate. Last time, there were about 3.5 months between when the court heard oral argument and when it issued a decision. Again, taking that as sort of an assumption here, that puts the decision around December. Could be December, January, February. It could be longer. Last time we had a unanimous decision that pretty easily ruled in our favor. So whether we win or lose, it might take longer. And I always advise clients and anyone out in the world, that and anybody who's telling you that they can guess the outcome of a case based on how long it takes or anything else like that. They may have some good ideas. They sometimes are on the right track, but all of those things are really case by case. So it's hard. It's really hard to know. But I think fall for oral argument, winter for a decision is a pretty aggressive timeline, but also a pretty good guess.
Great. Before we close and give each Andy and Jason a moment for a final word, let me add to the chorus of thanks to both Andy and Jason. An amazing amount of time has been spent defending these programs. I think a lot of our members have heard me say 54 million students a year attend K-12 schools that enjoy E-rate support. There's 16,000 healthcare providers out there that are getting rural healthcare support. Um, the impact of these programs is tremendous and it's profound around the country, and they wouldn't exist today but for the defense and the help that's being brought by our terrific lawyers. So we thank Andy and Jason and everyone else who's worked on these cases. So Andy, final thoughts on the case at this moment.
Well, uh, just to pick up for a moment on what Jason was saying about timing, uh, federal judges have lifetime tenure and they can do what they feel like doing. And Joey alluded to a decision that came out this morning on another provision of Communications Act where the Eighth Circuit Court of Appeals uh, took a year and 7 months to
Wow.
issue its decision after oral argument. Dissents can drag it out. Uh, there's a famous story about a case that ultimately wound up in the Supreme Court that was delayed for 2 years because this was pre-digital and the folder fell behind a radiator. So you never know. Uh, but I think Jason's guess on the timeline is what it is. Uh, I guess the only I'm repeating myself, but I think it's just important for everybody here to know. For the time being, we just keep on operating. We have issues with the E-rate portal and things like that that can
Sure.
change, but the fundamental uh, operation is unaffected by this litigation and hopefully will remain so.
Thank you, Andy. Jason.
I'll be brief. There's not much more for me to say about the substance of this. I will say this has been a team effort since these cases started in 2021 from, organizations like SHLB, organizations like Andy's clients, law firms, government lawyers, beneficiaries, members of these organizations who have contributed time and information. We're thankful to everybody who has helped us in this successful fight so far, and we appreciate everybody's continued support as we continue to move forward. And I guess one last shout out to the interveners who aren't on the call here, but at TCA and Jennifer Tatel and Dan Kahn at Wilkinson Barker Nauer,
Absolutely.
who've been part of this effort in the Fifth Circuit. And I hope we stop doing these webinars at some point because we've won and they've given up. But until then, we'll see you next time.
Excellent. Well, thank you, Jason. Thank you, Andy. Thank you, Chris and Cora, my partner in all of this. The fight continues, and really just appreciate all that you've done to protect these programs. And so we've come to the end of the webinar. A recording will be available on Shelby's website, so it is free and open for all to view either again or for the first time. We also want to thank our sponsors, Ready, Zayo, T-Mobile, Tirana, and Cisco. Also, many thanks again to the American Library Association, ALA, for co-hosting this important webinar and for again being with us every step of the way. Also, just remember, if you've enjoyed these webinars, please become a SHLB member today. It's easy to sign up. And if you enjoyed this webinar, we got another one next month. Andy just alluded to the new E-rate portal. We are doing a webinar on Wednesday, June 3rd, same time, same place, 2 p.m. Eastern. And the title of the webinar is Understanding the FCC's New E-rate Competitive Bidding Portal. We encourage folks to register today. Finally, we encourage everyone on this webinar to attend AnchorNets. It's the nation's leading broadband conference for anchors. It's where broadband policy meets real-world action. You should register today at anchornets.org, and we hope to see you in Crystal City October 7th through 9th. And as a sneak preview, we will be seeing Andy and Jason again. So Andy and Jason, we're not done. Hopefully, we'll either be right before or right after all arguments, and we'll get an update on exactly where we are in this case. So thank you again for attending and see you next time. Take care.